Welcome back and thank you for tuning in to the third installment of our series against intellectual property, where we study the ideas of Stefan Kinsella from his book Against Intellectual Property. In the first two chapters, we have learned what IP is, like what different kinds of intellectual property exist currently in the United States. Let's see if we can name the different kinds. So there are patents, what most of us are familiar with. These include like processes or new inventions. Then we have copyright, which is of course what we are also familiar with. If you've ever posted a video on YouTube with a song in it that is not really yours, quote unquote. You know what copyright is? Basically, this covers like artistic works. So the arrangement of words or tones in the song. And Then we have trade secrets, we had the example of Coca-Cola. So something that we just keep secret in our company, for example, and we contract so other people cannot really or by contract are not allowed to divulge this information. And lastly, we also have trademarks, which would cover, for example, the iconic font of Coca-Cola, the check mark of Nike, something like that. So something that is supposed to provide proof for the authenticity of a certain good. In the second episode, we took a look at the libertarian canon that already exists on the issue of intellectual property, ranging from thinkers like Ayn Rand, who are in favor of intellectual properties, to thinkers like Rothbard, who are against intellectual property. And then we also took a look at the utilitarian defense of intellectual property. So we learned we reminded ourselves that utilitarianism means the greatest good for the greatest amount of people. This is what is morally right, is morally good. And basically the arguments for IP were, well, if we do have intellectual property, this encourages innovation and like protects the inventor, that they spend so much time and resources on coming up with a new invention, and thereby incentivizes them to keep innovating. And we looked also at the natural rights defense of intellectual property. So this is more of the line that Ayn Rand followed in, saying that, well, if you own your mind, you own your ideas, and if you don't own that, well, what do you really own? So far we have just covered basic facts, things that can be commonly known if you are into that kind of issue. So summarizing the law of intellectual property and then looking at what other libertarian thinkers have said on this issue. And now we will actually dive into the third chapter of the book Against Intellectual Property, which is called IP and Property Rights. And to me, this is maybe the juiciest part of the whole book. So we are in for a good time. And here Kinsella will lay out his arguments on the issue of intellectual property. Before I start reading this third chapter, I want to reread the last sentence from the chapter 2, because this is kind of like the teaser for what is to come. And so I think it's nice to remind ourselves what he wrote there. Namely, a deeper problem for the natural rights position lies in its undue emphasis on creation instead of scarcity, as giving rise to property rights, and discussed below. And below, of course, is chapter 3, IP and property rights. So let's dive right in. Property and scarcity. Let us take a step back and look afresh at the idea of property rights. Libertarians believe in property rights in tangible goods, resources. Why? What is it about tangible goods that makes them subject for property rights? Why are tangible goods property? a little reflection will show that it is these goods' scarcity, the fact that there can be conflict over these goods by multiple human actors. The very possibility of conflict over a resource renders it scarce, giving rise to the need for ethical rules to govern its use. Thus, the fundamental social and ethical function of property rights is to prevent interpersonal conflict over scarce resources. As Hoppe notes, quote, "Only because scarcity exists is there even a problem of formulating moral laws. Insofar as goods are superabundant, free goods, no conflict over the use of goods is possible, and no action coordination is needed. Hence, it follows that any ethic, correctly conceived, must be formulated as a theory of property, i.e. a theory of assignment of rights, of exclusive control over scarce means, because only then does it become possible to avoid otherwise inescapable and unresolvable conflict." So the centerpiece of libertarian philosophy, maybe we could argue, is the realization that we live in a scarce world, that tangible goods, things that are all around us, things that we can touch, they only exist once. And so if it comes to the question, well, who has the right to control this resource, we may end up with some conflict. In the previous episode, I had the example of the bed. You're tired, you want to go to sleep, you stand next to a bed, and the question now is, can you just lay down and get some shut-eye, or will there be some conflict? Just when you are dozing off into the land of the dreams, somebody taps you on the shoulder and forces you to stand up, basically, and says, well, you can't sleep here. This is actually my bed. And then you have some conflict, right? You're just tired, you're woken up, and we can all imagine this situation. And this is just in the nature of our universe, that we live in a material world, and these materials can be fought over. So the issue can be solved by property rights. That if we have a set of rules that who owns what, who has the right to control a given resource, we can, in the example of the bed, you say, well, no, good sir, first of all, I'm not sure what you're doing in my house. And second of all, I bought this bed. This is my property. Here is the bill where I bought it with. I bought it with my own money. And then in the libertarian theory, you could go back further and further until you come to the point where somebody found nature-given resources and transformed them through their labor and effort into, I don't know, they cut the wood down, for the bed frame. They plucked the cotton that the mattresses are made out of. I'm not sure what mattresses are made out of. I mean, there are different kinds. So anyway, but eventually, if we follow this road, I bought it from the manufacturer of this. I bought it from IKEA. What the hell? And then you go to IKEA. Where did you get the resources from? They say, we got it from our supplier. You go to the supplier. Who did you get the resources from? We got them from this and that wood cutting firm. You go to that firm, and they they grew the wood and cut down the resource. And then if you want to go even further, you can say, well, who gave you the land to cut the wood, or grow the wood and cut it? And eventually you would end up at some individual who homesteaded the land, i.e. they were the first human to mix their labor with this land, and thereby claiming the property right. And then you can turn to the intruder and say, and you, good sir, what is your claim to now be in the position to lay down in this bed? And they would have to come up with their own argument. And the elegance of property rights is that we can solve this conflict without violence just by looking at the set of rules. And this is also brilliantly put forward by Rothbard in The Ethics of Liberty. Listening back to the other 2 episodes, I caught myself how often I mentioned this book, The Ethics of Liberty. And my first reaction was like, maybe I shouldn't have mentioned it so often. And then my second reaction was, no, this is the right amount to mention it because it's such a good book, such a good work. And if you're not familiar with The Ethics of Liberty, I highly encourage you to go to Mises.org and download the ebook or, order it from whatever book supplier you want and give it a good read. Because Rothbard really shows this, by just examining Robinson Crusoe and later on Friday on the Forgotten Island, the nature-based island without any other human being and property rights, how this entire system of libertarian property rights works and how it is based in reality. So the main thing we need to keep in our forehead is this concept of scarcity, that we are in a material world and atoms are scarce. You and I, we cannot have the control over the same arrangement of atoms at the same time. This will lead to some conflict, namely who will sleep in the bed. And if you're not in the mood for cuddling, you definitely have to resolve this problem. Lastly, what I want to mention about this here, I like this part from Hoppe's quote. Hence it follows that any ethic correctly conceived must be formulated as a theory of property rights. So this correctly conceived is exactly what I also is so much enjoyed about, you guessed it, The Ethics of Liberty, that in the first part, Rothbard points out the different rules we can possibly have. And there are basically just 3. One is you have libertarian property rights, and he goes on in the later part of the book to lay it all out. And the second one is you have group A who decides and group B just has to follow. This is basically a rulership, what we live under. And then you can have different kinds of rulership, whether it's a monarchy where you just have one person that decides, whether you have an aristocracy where a group of people decide, or whether you have a democracy where the majority decides. But it's all the same. It just comes in different flavors. And lastly, you have you have communism, true communism that, well, let's suppose that everybody owns everything a little bit, then we would have to get permission from everybody to make any decision. Like, can I get out of bed? Well, let me first ask the other 8 billion people on the planet and wait, actually, can I use the mouth of my body to ask this question? For this, I would also have to get permission. And Rothbard shows that very quickly humanity would die out under such a system. Of course, and he refers to this as communism. Communism as we come to know it in the 20th century is, of course, a little bit different about this. It more or less ends up as like an aristocracy where we have a group of people, basically the party, or maybe we have just one person like Stalin who decides, but at least that's the theory. So the brilliance about libertarian property rights is that it can exist. Like, it is conceivable to have this rule set that applies to everybody, anywhere, at all times. And it is logically possible that we don't have fallacies in our reasoning and so on and so forth. Whereas with the rulership, like, why is Group A in a higher position than Group B? Is it because of their blue blood that runs through their veins, or whether they are the noblest of people, whatever that may mean? But and communism, of course, the same. Like, they end up with this logical fallacy, and thereby we can already kind of, like, this is a non-starter. If we want to have rules, if we want to have rights, human rights, I mean, it's in the name, right? It should apply to all humans, then it must be applicable to any human, any place, at any time. Man, I could go on for another half hour about this point, but let's stick to the topic at hand, which is scarcity and intellectual property. So I continue reading. Others who recognize the importance of scarcity in defining what property is include Plant, Hume, Palmer, Rothbard, and Tucker. By the way, this is not Tucker Carlson, way earlier. All right. Nature then contains things that are economically scarce. My use of such a thing conflicts with, excludes your use of it, and vice versa. So think about the bed. The function of property rights is to prevent interpersonal conflict over scarce resources by allocating exclusive ownership of resources to specified individuals, owners. To perform this function, property rights must be both visible and just. Clearly, in order for individuals to avoid using property owned by others, property borders and property rights must be objective, intersubjectivity ascertainable. They must be visible. For this reason, property rights must be objective and unambiguous. In other words, good fences make good neighbors. All right, so I guess the point here, because when I was reading this, I was first taken a little bit aback. Like, you cannot see property rights. This is just a concept, like a mental model. But I guess the last sentence really puts it nicely. If you have some land, you have your farm, your homestead, whatever, and you put a fence around it, this makes a clear border of property. And then you can say, well, my fence runs here, so, on this side is my property, and on this side, Mr. Jones is your property. And if you don't have a fence, it's much harder to, say, hey, you came over to my lawn. Well, where does your lawn start and where does my lawn begin? So this is, ambiguous, right? And in order for us to have property rights, it must be clearly distinguishable. And there is also a footnote that I do want to read about this thing of visibility. So here he references Hoppe, A Theory of Socialism and Capitalism, page 140 to 141, and writes, I do not mean to restrict rights to the sighted. So things that you can see with your eyes. The term visible here means observable or discernible. I own this clarification to Jean Callahan. All right. So I guess this makes it a little bit more clearer. Of course, you cannot see the concept of property rights, but by marking or setting marks in the world, I have my pair of socks and I knit my name into it. It makes it very easy to discern it. Or I have a blue pair of socks and you have a green pair of socks, then it's much easier for us to distinguish or to discern whose property. Property rights must be demonstrably just as well as visible, because they cannot serve their function of preventing conflict unless they are acceptable as fair by those affected by the rules. If property rights are allocated unfairly or simply grabbed by force, this is like having no property rights at all. It is merely might versus right again, i.e., pre-property rights situation. But as libertarians recognize, following Locke, it is only the first occupier or user of such property that can be its natural owner. Only the first occupier homesteading rule provides an objective, ethical, and non-arbitrary allocation of ownership in scarce resources. So coming back to our example with the bed, let's say I do show my bill of purchase for the IKEA bed and then turn to my intruder and ask what is his claim to the bed, and he just pulls out a gun and sticks it in my face, then there's no concept of property rights here. This is what is meant by might versus right. That his gun in my face trumps my right, the just claim to the property. And if we live in this situation, there are no set rules. There's basically, I happen to be armed, you happen to be unarmed. Well, what is quote unquote yours is now quote unquote mine. And the best, like the very best concept that we can come up with, or that libertarians or any human for that matter has come up with so far, is this idea of, well, at some point in time there were no humans on Earth. And then humans evolved and started with their capacity for reason to mix their labor with the land, build a bow and arrow or build a shed or whatever, cut down some trees to make a meadow and whatever. And this is really clearly illustrated in this Crusoe example, that Crusoe arrives on an island where there are no humans, and he begins to homestead the land and thereby acquiring ownership over it. And this gives a very easy rule. If you have some land and you want to decide, okay, who is the rightful owner, you just go back in time and the two conflicting parties go on and try to prove their better claim. And then whoever ends up with the better claim, well, that's the just owner. When property rights in scarce means are allocated in accordance with first occupier homesteading rules, property borders are visible and the allocation is demonstrably just. Conflict can be avoided with such property rights in place because third parties can see and thus sidestep the property borders and be motivated to do so because the allocation is just and fair. So let's say Robinson is on his island, and let's say he's in the south part of the island and he begins to, construct fishing nets and cast them into the water there, and he cuts down some trees and builds a hut. And you can, think about this scenario. You can clearly see where Robinson has worked, where he has mixed his labor with the land. And then when Friday comes to the island, he has this visible boundary where you can say, okay, this is the house of Robinson. In order to avoid conflict, I should move to the north part of the island and homestead that land. And what we end up with then is a situation where there is no conflict, Friday doesn't invade the property of Robinson and tries to sleep in his bed, and they just can get along fine. But surely it is clear, given the origin, justification and function of property rights, that they are applicable only to scarce resources. Were we in a Garden of Eden, where land and other goods were infinitely abound, there would be no scarcity and, therefore, no need for property rules. Property concepts would be meaningless. The idea of conflict and the idea of rights would not even arise. For example, your taking my lawnmower would not really deprive me of it. I could conjure up another in the blink of an eye. Lawnmower taking in these circumstances would not be theft. Property rights are not applicable to things of infinite abundance because there cannot be conflict over such things. And I think, here, now we are in the juicy part, and I hope you notice the juiciness. This is the entire crux of the situation. If you take my bed and try to sleep in it, and I'm tired and I want to lay down, now I don't have a bed to lay down in. But if we are, just for the sake of argument, hypothetically, in a place where with the snap of your finger, you can just create beds, whatever you're dreaming about, or you're thinking about, okay, somebody is in this bed, I snap my finger and I create another bed and I go lay down in this bed. There is really no sense of having my bed or your bed. And this example clearly isolates this concept of scarcity as the underlying reality of why we do need property rights. Because unfortunately, we don't live in this Garden of Eden. Unfortunately, if we want to have a bed, we either have to drive to IKEA and buy one, or we have to homestead some land, grow some wood, cut the wood down, grow some cotton, create a mattress, whatever, and then end up with a bed. So this is just the reality. We cannot snap our fingers and make matter out of thin air, and therefore we need to have some rule set that reduces the conflict in the world, and if there is conflict, gives us the guiding light to resolve this conflict. Thus, property rights must have objective, discernible borders and must be allocated in accordance with the first occupier homesteading rule. Moreover, property rights can apply only to scarce resources. The problem with IP rights, and now we get into the good part, is that the ideal objects protected by IP rights are not scarce. And further, that such property rights are not and cannot be allocated in accordance with the first occupier homesteading rule, as will be seen below. Okay, so if you are not convinced yet, this is... I mean, we are doing like a whole series here on against intellectual property right, but this is really the thing. With the bed, we can have conflict over it. Like either I sleep in the bed, you sleep in the bed, or we decide to cuddle for whatever reason. But with ideas, it's really not the same thing. Like there is no scarcity. I don't want to spoil too much, so let's just plow on ahead and continue reading Scarcity and Ideas. Like the magically reproducible lawnmower, or in my case, a bed, ideas are not scarce. If I invent a technique for harvesting cotton, your harvesting cotton in this way would not take away the technique from me. I still have my technique, as well as my cotton. Your use does not exclude my use. We could both use my technique to harvest cotton. There is no economic scarcity and no possibility of conflict over the use of a scarce resource. Thus, there is no need for exclusivity. So, I'm unsure what I want to say here because I don't want to spoil too much of what is to come, although I'm not quite sure what is to come. But this entire concept of property rights is like, we have a problem, we have the physical world, we try to come up with a solution for it, i.e. property rights and the homestead principle, and we apply it to tangible goods. And this leads us into a world where when we have conflict, we can resolve it. And we can do this so very efficiently. And ideally, we prevent the conflict in the first place because everybody respects the property rights and everybody is able to discern who owns what and then just respects these boundaries. So I see, okay, there is a bed. I didn't buy it. I didn't build it. Beds don't grow on trees. So this is not my bed. And I cannot lay down in this bed now. And then you, like an hour later, don't have to come and wake me up and tell you, well, actually, you slept in the wrong bed, my friend, and now get out of my house. And actually, what are you doing in my house? But that's another issue. And now we continue thinking about the world with our great invention of property rights, and we think about this realm of the ideas, and it's like, oh, we already have this idea of property rights. We should also apply this idea of property rights to ideas. And this is wrong because first we need to have the problem, like with ideas. Do we have a problem? Let me think of a pink elephant. Now you also think of a pink elephant. But I'm still thinking about the pink elephant. There is no conflict, right? With ideas, they can multiply ad infinitum. It is really the Garden of Eden when it comes to ideas. Like, we can think of anything we can think of. And we can do so all at the same time without having conflict over it. So why do you even need property rights in ideas? Like, what's the problem that you're solving with it? All right, let's continue. Similarly, if you copy a book I have written, or in my case, I read a book that Stefan has written, I still have the original tangible book. And I also still have the pattern of words that constitute the book. Thus, authored works are not scarce in the same sense that a piece of land or a car is scarce. If you take my car, I no longer have it. But if you take a book pattern and use it to make your own physical book, I still have my own copy. The same holds true for inventions and indeed for any pattern or information one generates or has. As Thomas Jefferson, himself an inventor as well as the first patent examiner in the US, wrote, "He who receives an idea from me receives instruction himself without lessening mine, as he who lights his taper at mine receives light without darkening me. Since use of another's idea does not deprive him of its use, no conflict over its use is possible. Ideas, therefore, are not candidates for property rights." Even Rand okay, so before we go to Rand, but I think this is such an important point that we are trying to solve a non-problem. It's like we have this genius invention of property rights, and it is genius indeed, but we are so enthused by the idea and by the concept that we now want to smack everything with that hammer. You know, if all you have is a hammer, everything looks like a nail, and then you're super eager to say, well, yeah, let's apply this to everything. Let's apply it to the realm of ideas as well. And the issue here is, why? Why are you doing this? You are solving a non-issue, and therefore it's a non-starter. Like, you are not solving a problem. There is no problem. Now, okay. Even Rand acknowledged that, quote, intellectual property cannot be consumed, end quote. So again, with scarce resources, yeah, like Ayn Rand is famous for the saying, you cannot have your cake and eat it too. And that is so true. Yeah, she has such a good point with that. But then intellectual property doesn't have this issue. Yeah, like you can, like Stefan Kinsella pointed out in the earlier paragraph, if you copy a technique from somebody else, the original person still has their technique. You're not depriving them of anything. Ideas are not naturally scarce. However, by recognizing a right in an ideal object, one creates scarcity where none existed before. Okay, so you're like the world, the Garden of Eden, like you're killing that vibe by introducing the property rights or intellectual property rights. You start creating scarcity. As Arnold Plant explains, quote, "It is a peculiarity of property rights in patents and copyrights that they do not arise out of the scarcity of the objects which become appropriated. They are not a consequence of scarcity. They are the deliberate creation of a statute law, whereas in general the institution of private property makes for the preservation of scarce goods, tending to lead us. To make the most of them, property rights in patents and copyrights make possible the creation of a scarcity of the products appropriated which could not otherwise be maintained." So it is only because of the laws regarding intellectual property, the laws regarding patents and copyrights, that there is some kind of scarcity in ideas. Because if you hold a copyright, if you hold a patent, that makes it scarce. Like, it excludes everybody else from that pattern of words or that invention that you made. So you arbitrarily in the world, like artificially is the right word, you create this scarcity that naturally wouldn't be there. Burckhardt, I hope I pronounced this right, also argues that natural scarcity is what gives rise to the need for property rules and that IP laws create an artificial, unjustifiable scarcity. As he notes, quote, natural scarcity is that which follows from the relationship between man and nature. Scarcity is natural when it is possible to conceive of it before any human, institutional, contractual arrangement. Artificial scarcity, on the other hand, is the outcome of such arrangements. Artificial scarcity can hardly serve as a justification for the legal framework that has caused that scarcity. Such an argument would be completely circular. On the contrary, artificial scarcity itself needs a justification. So it's kind of like the snail eating its own tail when we need intellectual property because ideas are scarce. Why are ideas scarce? Because of the laws of intellectual property. So we end up in this circular argument that needs justification itself. Like, why are we even in this circle? Because in the natural world, there is no conflict over these intangible goods, or whatever you may call them, ideas. Thus, Burckhardt maintains that only naturally scarce entities over which physical control is possible are candidates for protection by real property rights. For ideal objects, the only protection possible is that achievable through personal rights, i.e. contract. More on this below. I really like this idea of, you have a candidate for something. Maybe you've seen these casting shows like, what is it called? American Idol or The Voice or whatever. And you have all these different candidates. And through the rounds, the judges decide and the audience decides like who's going to proceed to the next round and finally win. And it's kind of the same thing in the realm of philosophy, that we have these two concepts. We have the tangible goods and the intangible goods. And now we decide, okay, which one is actually a good candidate, a possible candidate for physical control. And here, Burckhardt, or I'm not sure if I pronounced his name correctly. If not, I apologize, sir, that the only possible candidate is naturally scarce entities over which physical control is possible. So an idea, like there's no physical control possible over this really. Like, if I tell you a secret, then like short of me forcing you to stay in a dark basement or whatever, I don't really have control over that idea anymore. Only tangible, scarce resources are the possible object of interpersonal conflict. So it is only for them that property rules are applicable. Thus, patents and copyrights are unjustifiable monopolies granted by government legislation. It is not surprising that, as Palmer notes, monopoly privilege and censorship lie at the historical root of patent and copyright. It is this monopoly privilege that creates an artificial scarcity where there was none before. In other words, if we are consistent with libertarian principles and philosophy, it's just a fact we have to recognize. Okay, ideas. They are not scarce. They, by nature. And therefore, having a state, a government, which legislates their scarcity, is unjustified. Yeah, there is no grander or bigger justification for it. It's just legal positivism in the sense that it's because the government says so. And I mean, libertarians, we don't think that rights are made by the government. So if there is no natural justification for it, not even a utilitarian justification, then why are we even having this argument? Let us recall that IP rights give to pattern creators partial rights of control, ownership, over the tangible property of everyone else. The pattern creator has partial ownership of others' property by virtue of his IP right, because he can prohibit them from performing certain actions with their own property. Author X, for example, can prohibit a third party Y from inscribing a certain pattern of words on Y's own blank pages with Y's own ink. And I mean, here sometimes when you have these weird ideas, kind of like intellectual property, and you think, okay, let's go with that. Let's make the unethical ethical in our books. You end up with these really weird consequences. And I think this right here is one of such consequences that, let's say I buy Harry Potter. Yeah, I like that book very much. And I also buy some ink and some pages. Yeah, this is all ownership under the libertarian principle, which is under my control. I can do with it what I please. And now I'm such a big fan of J.K. Rowling and Harry Potter that I begin to copy, like I read the book and I copy word for word, period for period, every letter in that book. Under basic libertarian principles, there's nothing wrong with this. But with intellectual property, well, you just stole from J.K. Rowling, basically. You took her property. So, no, you can't put that ink on your blank pages. And this ends up in this weird conundrum where, well, okay, so what am I now allowed to do and what not? And I mean, of course, the answer is very simple. It's unjust. It's unjustifiable even to have these intellectual property laws, and by having them, we end up in these weird situations. That is, by merely authoring an original expression of ideas, by merely thinking of and recording some original pattern of information, or by finding a new way to use his own recipe, the IP creator instantly, magically becomes a partial owner of others' property. He has some say over how third parties can use their property. IP rights change the status quo of redistributing property from individuals of one class, i.e. tangible property owners, to individuals of another, authors and inventors. Prima facie, therefore, IP law trespasses against or takes the property of tangible property owners by transferring partial ownership to authors and inventors. It is this invasion and redistribution of property that must be justified in order for IP rights to be valid. We see then that utilitarian defenses do not do the trick. Further problems with natural rights defenses are explored below. So we end up in this weird situation where the inventor, the author, suddenly, becomes partial owner of your ink, your book, and can prevent you from doing something with it that otherwise you should be able to do. And this is kind of like a bizarre side effect of this concept of intellectual property. And, now we are very much in the realm of philosophical ideas here. And you may ask yourself, okay, Alex, this is all good and well, but what does this have to do with my life? And maybe you haven't noticed, but this is all around us. The other week I was watching a YouTube video on music creators that now, I don't know what these kids are listening to these days, but Dua Lipa or whatever, they take some very known music patterns from the past, from the 80s that were popular then, and kind of recycle them and create their own music on top of it. And they do it in such a way to be protected, to not be suable by the original copyright holder, to now say, well, your song is very much similar to mine, and now I own basically your song. And if you make money with it, I actually do make money with it. And in music, this is omnipresent. If you are on YouTube, this is omnipresent. You cannot just play the music. What do you mean you play the music on your own music boxes from some other artist? No, that is theft, my good sir. And your video will be copyright struck, i.e. all money that you make from that video will now be reallocated to the original holder of that copyright. So, and then the YouTubers know this and they don't want this to happen, right? And so they try to find ways around it. And so this concept of intellectual property and copyrights is distorting our entire world that we live in. And maybe now that I have said it, pay some attention to it. Try to find some instances where people are altering their behavior because otherwise they would infringe upon quote unquote rights or intellectual property rights of other people. And I mean, once you see it, you cannot unsee it. It's all around us. This is so invasive and it perverts basically everything it touches, you know, because it inverts this whole thing. Like suddenly you are a thief for using or like recycle, like think about what music would be without copyright. You know, some artist sings into a microphone, records it and plays their guitar and everybody can reuse this or change it in some way and still be I guess they wouldn't be the owner either. Like nobody owns this, right? If you make a song, if you write a book, once you blast your ideas into the ether, much like I do with this podcast right now, I'm not the owner of it anymore. You own maybe the phone, the laptop that has the MP3 file of my voice saying this, of the song playing, of the book, yeah, the ebook or whatever. But I don't own this file. I don't own part of your computer, of your phone. And in the libertarian world, you can do with this whatever you want. You know, you can put my podcast on your podcast feed. I heard that some people do that. And that's totally fine in the libertarian sense. You could put some music under it. You could clip it. You could watch and react as some people do. And in our modern world, this is really a big problem that when you do this, you are potentially you make yourself vulnerable to be sued by somebody who claims that they are the proper of the intellectual property that you used. All right, let's explore creation versus scarcity. And we had this concept in the last chapter. So Ayn Rand, for example, was also mentioning this. Some inconsistencies and problems with natural rights theories of IP were pointed out above. This section discusses further problems with such arguments in light of the preceding discussion of the significance of scarcity. As noted before, some libertarian IP advocates, such as Rand, hold that creation is the source of property rights. This confuses the nature and reason for property rights, which lie in the undeniable fact of scarcity. Given scarcity and the correspondent possibility of conflict in the use of resources, conflicts are avoided and peace and cooperation are achieved by allocating property rights to such resources. And the purpose of property rights dictates the nature of such rules. For if the rules allocating property rights are to serve as objective rules that all can agree upon so as to avoid conflict, they cannot be biased or arbitrary. For this reason, unowned resources come to be owned, homesteaded, or appropriated by the first possessor. The general rule, then, is that ownership of a given scarce resource can be identified by determining who first occupied it. There are various ways to possess or occupy resources, and different ways to demonstrate or prove such occupation, depending upon the nature of the resource and the use to which it is put. Thus, I can pluck an apple from the wild and thereby homestead it. Or I can fence in a plot of land for a farm. It is sometimes said that one form of occupation is forming or creating the thing. For example, I can sculpt a statue from a block of marble or forge a sword from raw metal, or even create a farm on a plot of land. We can see from these examples that creation is relevant to the question of ownership of a given created scarce resource, such as a statue, sword, or farm, only to the extent that the act of creation is an act of occupation, or is otherwise evidence of first occupation. However, creation itself does not justify ownership in things. It is neither necessary nor sufficient. One cannot create some possibly disputed scarce resource without first using the raw materials used to create the item. But these raw materials are scarce, and either I own them or I do not. If not, then I do not own the resulting product. If I own the inputs, then, by virtue of such ownership, I own the resulting thing, which I transform them. Consider the forging of a sword. If I own some raw metal, because I mined it from the ground I owned, then I own the same metal after I have shaped it into a sword. I do not need to rely on the fact of creation to own the sword, but only on my ownership of the factors used to make the sword. I do not need creation to come to own the factors, since I can homestead them by simply mining them from the ground and thereby becoming the first possessor. On the other hand, if I fashion a sword using your metal, I do not own the resulting sword. In fact, I may owe you damages for trespass or conversion. So this makes me think of, again, you guessed it, the ethics of liberty, where I think it is the ethics of liberty, where Rothbard describes this example of a entrepreneur, or a capitalist, somebody who owns a factory and they employ workers to manufacture shoes or whatever. And the capitalist owns the factory, he owns the raw materials that are used to produce shoes, and the worker on the line don't. And the fallacy I guess this also, the fallacy of Marx is to think that, well, who is actually making the shoes? Well, it's the worker. The worker owns that shoe now. But in the libertarian world, this question never arises, because you go back to who originally owned the factors, as Kinsella calls it, the raw materials that went into the transformation. And the answer here is clear. The worker does not own these input factors, and therefore they do not own the resulting property. And I like this idea. Let's say, your neighbor has a big garden that is wild and overgrown, and now you come into this garden and you start sculpting one of the trees to look like a duck or whatever. And by doing this, you're creating this duck tree. But then when your neighbor gets home, they may be upset with you because you trespassed on their property and you converted something that's not yours into something else. And now that neighbor may sue you for restitution of the damages that you've caused. So, the creation, therefore, is neither necessary nor sufficient to establish ownership. The focus on creation distracts from the crucial role of first occupation as a property rule for addressing the fundamental fact of scarcity. First occupation, not creation or labor, is both necessary and sufficient for the homesteading of unowned scarce resources. In other words, we could say that this idea of creation, fantastic as it may be, or idealistic as it may be, for Ayn Rand, this was a big part that we have prime movers who are doing things in the world from their own intrinsic motivation. And I mean, totally agree with that. And that's great. But when it comes to property rights, this is really the wrong thing to focus on. Because as we just saw with the example of the duck tree, just creating something does not mean you own it. Whereas, I read the sentence again because it's really important, first occupation, i.e. homesteading, not creation or labor, is both necessary and sufficient for the homesteading of unowned scarce resources. And, we have this, these words, necessary and sufficient. These are very important. When we think about philosophy, a necessary condition is something that without this condition, there's really nothing else to talk about here. Like, you need to have this condition to be true in order to proceed. And sufficient is, hey, once you have this, then you can stop. Like, it stops there and you're done with your work. So this first occupation being both necessary and sufficient is like, you have to kill two birds with one stone with this principle. Because, when we think about input factors such as metal or leather for the shoes, without this first occupation, they wouldn't exist. And once you have these raw materials, you already know who the first appropriator and thereby owner is. So it is necessary and sufficient in this sense. One reason for the undue stress placed on creation as the source of property rights may be the focus by some on labor as the means to homestead unowned resources. This is manifest in the argument that one homesteads unowned property which one mixes one's labor because one owns one's labor. However, as Palmer correctly points out, occupancy, not labor, is the act by which external things become property. By focusing on occupancy rather than labor as the key to homesteading, there is no place to creation as the fount of property rights, as objectivists and others do. Instead, property rights must be recognized in first comers or their contractual transferees, in order to avoid the omnipresent problem of conflict over scarce resources. Creation itself is neither necessary nor sufficient to gain rights in unowned resources. Further, there is no need to maintain the strange view that one owns labor in Further, there is no need to maintain the strange view that one owns one's labor in order to view things one first occupies. Labor is a type of action, and action is not ownable. Rather, it is the way that some tangible things, example bodies, act in the world. Alright, so again, a very nuanced take here that we should also not focus on the labor part, instead focus on the occupancy part. And I guess occupying means that with my body, I am somewhere in the world and I do something in the world. Basically, I guess this is first come, first serve. And once something is owned, you can transfer it, the ownership, to somebody else. The problem with natural rights defense of IP then lies in the argument that because an author, inventor, creates something, he thus entitled to own it. He is thus entitled to own it. The argument begs the question by assuming that the ideal object is ownable in the first place. Once this is granted, it seems natural that the creator of this piece of property is the natural and proper owner of it. However, ideal objects are not ownable. Under the libertarian approach, when there is scarce ownable resource, we identify its owner by determining who its first occupier is. In the case of created goods, i.e. sculptures, farms, etc., it can sometimes be assumed that the creator is also the first occupier by virtue of the gathering of raw materials and the very act of creation, imposing a pattern on the matter, fashioning it into an artifact, and the like. But it is not creation per se that gives rise to ownership, as pointed out above. For similar reasons, the Lockean idea of mixing labor with a scarce resource is relevant only because it indicates that the user has possessed the property. For property must be possessed in order to be labored upon. It is not because the labor must be rewarded, nor because we own labor and therefore its fruits. In other words, creation and labor mixing indicate when one has occupied and thus homesteaded unowned resources. So we are dealing with an indication, but not with a proof. You know, I could labor on the land of my neighbor, and I wouldn't really be the just owner. By focusing on creation and labor rather than on first occupancy of scarce resources as the touchstone of property rights, IP advocates are led to place undue stress on the importance of rewarding the labor of the creator, much as Adam Smith's flawed labor theory of value led to Marx's even more deeply flawed communist view on exploitation. As noted above, for Rand, IP rights are, in a sense, the reward for productive work, i.e. labor, and Rand and other natural rights IP proponents seem to adopt a mixed natural rights utilitarian rationale in holding that the person who invests time and effort must be rewarded or benefit from this effort. Example, Rand opposed perpetual patent and copyright on the grounds that because distant descendants did not create their ancestors' works, they deserve no reward. On this point, I think this is kind of weird because did Ayn Rand also object to inheritance? Because, I mean, inheritance is the same thing, right? The child did not create the wealth that the parents pass on. So by the same argument, Ayn Rand should oppose inheritance. But this is contradictory to property rights altogether. Because if I own something, if I hold the just title to exclusive control of something, I also can transfer that title. And whether the person I transfer it to has created it or not is completely besides the point. I can also gift something, right? Ayn Rand abhorred this idea of the unearned, the undeserved, but in the theory of property rights, there's no issue with that. Of course, you can gift something to somebody else. You can transfer your property title without receiving anything in return. And I mean, inheritance would be just that, right? In addition, in a strange admixture of natural rights and utilitarian thinking, the natural rights IP approach implies that something is property if it can hold value. Oh boy. But as Hoppe has transiently shown, one cannot have a property right in the value of one's property, but only in its physical integrity. Moreover, many arbitrarily defined things can acquire economic value if government grants a monopoly over the thing's use, even if the thing is not otherwise a scarce resource. Example, the postal service's monopoly power to deliver first-class letters. And I mean, value is subjective, right? That's the whole core tenet of the Austrian School of Economics. So subjective means it's in the head of every person. And of course, just like you don't have a right to control the head of another person, you cannot thereby control the value of a thing. So it is very astute for Hoppe to point this out, that you have, as he puts it, the property in the physical integrity, but not in the value, i.e. the valuation of a thing in some other person's head. Thus, because ideas are not scarce resources in the sense that physical conflict over their use is possible, they are not proper subject of property rights designed to avoid such conflicts. Or as we have seen before, they are not a good candidate for it. Two types of homesteading. What, though, is really wrong with recognizing new property rights? After all, since new ideas, artistic creations and innovations continually enrich us, what is the harm in moving with the times by recognizing new forms of property? The problem is that if property rights are recognized in non-scarce resources, this necessarily means that property rights in tangible resources are correspondingly diminished, compromised. Yeah, inventing the IP rights kills the first step, right? So if we want to build upon it, we need to have something that can be that can be thought up without infringing on the first step. Because with the first step, I mean, at least us libertarians, we have already established that this is true. This is because the only way to recognize ideal rights in our real scarce world is to allocate rights in tangible goods. For me to have an effective patent right, a right in an idea or pattern, not in a scarce resource, means that I have some control over everyone else's scarce resources. So this is a clear contradiction, I would say. In fact, we can see that IP rights imply a new rule for acquiring rights in scarce resources, which undercuts the libertarian homesteading principle. For according to Lockean libertarian homesteading, it is the first occupier of a previously unowned scarce resource who homesteads it, i.e. becomes its owner. A latecomer who seizes control of all or part of such owned property is simply a thief, because the property is already owned. The thief effectively proposes a new and arbitrary homesteading rule to replace the first occupier rule, namely the particularistic rule, quote, I become the owner of property when I forcibly take it from you, end quote. Of course, such a rule is no rule at all, and it is clearly inferior to the first possessor rule. The thief's rule is particular, not universal. It is not just and it is certainly not designed to avoid conflicts. Right? So I think this universal, this is a really important word for philosophy, because when we try to think about human rights, as I said in the beginning, we need to be able to universalize this rule, i.e. to apply it to all people at any place, at any time. And if that's not possible, then it's not even a candidate for a human right. Proponents of IP must also advocate a new homesteading rule to supplement, if not replace, the first possessor homesteading rule. They must maintain that there is a second way for an individual to come to own tangible property. To wit, the IP advocate must propose some homesteading rule along the following lines, quote, a person who comes up with some useful or creative idea which can guide or direct an actor in the use of his own tangible property, thereby instantly gains a right to control all other tangible property in the world with respect to that property's similar use. End quote. This newfangled homesteading technique is so powerful that it gives the creator rights in third parties already owned tangible property. For example, by inventing a new technique for digging a well, the inventor can prevent all others in the world from digging wells in this manner, even on their own property. To take another example, imagine the time when men lived in caves. One bright-eyed guy, let's call him Galt Magnon, decides to build a log cabin on an open field near his crops. To be sure, this is a good idea, and others notice it. They naturally imitate Galt Magnon, and they start building their own cabins. But the first man to invent a house, according to IP advocates, would have a right to prevent others from building houses on their own land with their own logs. or to charge them a fee if they do build houses. It is plain that the inventor in these examples becomes a partial owner of the tangible property. Example, land and logs of others, due not to his first occupation and use of that property, for it is already owned, but due to his coming up with an idea. Clearly, the rule flies in the face of the first user homesteading rule, arbitrarily and groundlessly overriding the very homesteading rule that is at the foundation of all property rights. I mean, can you imagine living in such a world, coming out of the cave, seeing this Galt Magnan guy, bright, blue-eyed, building his magnificent cabin next to his crops, and then you turn to your wife and he's like, "Hey, honey, this looks pretty interesting. Maybe we should give it a go." And then you chop some wood and you start building your own cabin next to your crops, and suddenly this Galt Magnan guy struts along and tells you, "Ha! Stealing my idea, I see, huh? Now, this is not okay. You have to pay me some fee. I'm gonna license my idea to you. And if you don't do this, I'm gonna steal something from you." Like, it is, when he puts it like this, I think it's so obvious how flawed the idea of IP rights is. And I think this clear contradiction should make it clear in everybody's mind that, yeah, what are we doing here? It's not possible to have this. Or if we want to have IP, by whatever reason, arbitrary whim, I guess, we cannot have property rights as described in the libertarian canon, right? Because these two contradict each other. At least the IP contradicts the first user homesteading principle. There is, in fact, no reason why merely innovating gives the inventor partial ownership of property that others already own. Just because a rule can be proposed does not mean that it is workable or just. There are many arbitrary rules one could dream up by which property rights could be allocated. For example, a racist could propose that any white person can homestead any property already first homesteaded by a black person, or the third occupier of a scarce resource becomes its owner. Imagine that, the third occupier, genius. Or the state can homestead all capital goods even if already first acquired by individuals. Or by legislative decree, the state can homestead in the form of taxes part of the estates that are already owned by private individuals. All such arbitrary homesteading rules including the IP rule that innovators homestead partial control of all others' tangible resources, are unjustifiable. They all conflict with the only justifiable homesteading rule, first occupation. None of them establish fair, objective rules that avoid interpersonal conflict over scarce resources. Discussions of protecting rights in ideas, creations, or things of values only serve to obscure the fact that the proponent of IP proposes the unadulterated right to homestead and own private property. End of chapter. Wow. Okay, so this was really a tour de force, as they say in France. And let's read the last part here again, because I think this sums it up really well, what we have learned in this chapter. All such arbitrary homesteading rules, including the IP rule that innovators homestead partial control of all others' tangible resources, are unjustifiable. They all conflict with the only justifiable homesteading rule, first occupation. None of them establish fair, objective rules that avoid interpersonal conflict over scarce resources. Because this is how we started out. right? The scarcity aspect to property rights. This is the reason why we need property rights, to avoid interpersonal conflict. And interpersonal meaning between people. So we need to have these clear, as we read earlier, visible and just boundaries for property. And the best argument or the best principle we can come up with is this first occupation. That is a necessary and sufficient condition to acquire property from nature given resources. And now, when we clearly, without the muddying of the water with creation and ideas and things of values, we look at this issue, we can see very clearly that the proposed IP rule contradicts the rule for first occupation and property rights in tangible goods. And if we have these IP rules, then the inventor suddenly becomes partial owner to the tangible property justly acquired by everybody else. So if we are, consistent libertarians, this is really a non-starter for discussion. And luckily, the whole issue arises because with ideas, you don't have conflict over the ideas. Earlier I stopped myself, but now I guess I can say it. This is the thing, these advertisements with, you wouldn't steal a car before a movie played when they wanted you to stop pirating the movie. Even this term, pirating and stealing the movie. And even when I was talking earlier about this video I watched about artists stealing other music that was popular in the 60s and 80s. What? This is not stealing. You're not taking anything from the original creator. They still have their music if they're still alive. And, you're not taking anything from them. If you have a car or a bed, one person gets to sleep in that bed. One person gets to sit at the steering wheel and decides where the car goes. So there's conflict there, right? But with all things that come to the intangible realm, to the realm of ideas, there is no conflict. Why are we creating a problem? And we saw in this chapter that the problem arises because of the state interfering in this area and imposing these property rights on, things that don't really have conflict over them, and thereby introducing conflict and being a snail that eats its own tail, that the IP laws create the scarcity, and then you have the scarcity and you need some laws and whatever. So that's the chapter 3 from Against Intellectual Property. I hope you learned something from this chapter. I think this is really the core of the argument. And while there is one more chapter, I think this is really, we have to drive this point home. And even if you already agreed with opposing intellectual property, I think it's super important to have this firm philosophical grounding to be able to say, okay, it's actually not the labor, not the creation that generates property. It's this principle of being the first occupier. And having this clarity in our mind helps us avoid contradictions in the future. Contradictions, for example, as intellectual property. So, and on this basis, we can oppose patents and copyright. This was in an earlier chapter we read. This is the main part of this book, that we come to learn that these two things are unjustifiable. And I guess in this chapter, we have learned this. So if you like this content, if you like my episode, go to alexanarcho.live and subscribe to my podcast. And if you really liked it, then leave me a tip on xmrchat.com/alexanarcho. I will also leave a link in the show notes. This is basically a website where you can send me a message along with some Monero XMR and tell me how great it was or how badly it sucked, whatever you want to do. And then I get the money you transferred. So For all who do that, thank you so much. As with anything that I produce with this podcast, it's yours. Or it's not yours. But it's not mine either. Like, you can, if you found a part of this episode that was particularly cool and you want to share it on social, go ahead and clip it. I will not copyright strike you because I don't believe in copyrights. And yeah, armed with this philosophical underpinning, we will march onward into the 4th chapter of Against Intellectual Property. See you in the next episode.